please note that we prefer you to summarize what your key points are so it's covered adequately in the report. And then obviously you know that we don't have the powers that the Standing Committee on Finance has in respect of a bill of this nature, but we do have an important role and we will play it to the fullest. So having said that, welcome all over then to the first stakeholder. But before we do, Nkululeko, have you got any apologies from anybody?
Not at all, Chairperson. All members are here.
Right, good. Okay. I was looking at it this morning. Oh, may I also stress to members that we have several other, I think 4 other submissions which people have decided they don't want to speak to this morning. And they're just as important as, and some of them are just very short, like 2 of them are 2 page each or less than a page each. Never mind. They are just as important, sorry. They are just as important and they have to be taken very seriously, as indeed given the same weight as those who appear for oral submissions. So I have already primed the staff to prepare our position on an overview, if you like, and hopefully they'll have it tomorrow night or by Friday, 1 o'clock, before we meet at 2, sitting out at least independently from Treasury what we think the key issues are that have emerged from these public hearings. So that will be done on the side of the staff. They will have something ready. And on the side of Treasury, they too will be ready to reply to the civil society stakeholders. All right, over then 15 minutes each. We shall time you on the cell phone here, the stopwatch. And the first is the NPO working group. Thank you.
Good morning, colleagues. Thank you for this opportunity to comment on the B version of the bill and to articulate our views in this forum. I'm just going to share my screen quickly. Is that working? Can you all see it? I am Anne. Anne, can you see it? Can you give me a thumbs up because I can see you? Yes. Mike, thank you. My colleague Anne Barn and I are here presenting on behalf of the NPO Working Group. I'm Nicole Copley from NGO Law. Just in terms of the picture on the front page, we've taken to calling this bill the octopus bill because of all the places its tentacles reach and also how hard it's been to wrangle with. Especially given the short space of time which we have all had. Chair, we concur with your comments. It's been extremely pressured and a stressful process. And we just feel that a far better and more enforceable result could have been achieved with proper, timeous and advanced consultation with the sector in particular. Here we go, though, in terms of our timing. In terms of our general response to the bill as amended now in the B version, we're very relieved that the mandatory registration for all nonprofits has been dropped and that a risk-based approach has been taken with a more defined focus group. We also support the multi-pronged approach and a tailored approach to beneficial ownership in terms of the adjustments made, and also the consideration given to privacy rights, especially in the amendments to the Non-Profit Act, have been appreciated. We still think, and I know that it's, as you say, late and time pressured, that there are other better ways to achieve and neater ways to achieve what the bill is trying to achieve in terms of regulatory outcomes and oversight of the details. And I'll speak to that quickly in a slide in a minute. We just wish to note that there is a parallel process of doing a full scan of the NGO sector and an assessment of the risks. Of course, once again, this should have been done 2 or 3 years ago. And just as a final note, one of the things we really want to state is that we wish to take this opportunity to say that the NPO registry really needs to move house. It needs to come out from under DSD and be a properly funded, credible operational structure. And the non-profit sector is rallying around that cause at the moment. However, above all, we are glad that no knitting clubs are required to register under the B version of the bill. All right. So this is our suggestion as an alternative that we put in front of Treasury, and we just think that they've gone too far down the lane with the NPO registration and couldn't back out of it. But we think that there's a much neater way to accomplish it, and that is to place it under FICA and to create, there's a category under FICA of what are called reporting institutions. These are not your heavy onerous obligations of accountable institutions, and currently the only kinds of organization inside of this are Krugerrand and car dealers. These two these only inhabitants of this list of reporting institutions in the schedule would seem to us to align very well with the class of nonprofits, and in other words, nonprofits making donations or conducting activities cross-border that are seen to be at risk. And this slide is our suggestion of how we think that instead of making NPO registration compulsory under DSD, it could have just been housed under FICA. So this is just a little summary, and you'll all have the slides to look at your leisure of the consequences of if the FIC suggestion were taken up. The advantages of having the compulsory targeted nonprofits registered under FICA.
Hello.
Yes.
Yeah. You're going too fast, really. Remember, we are finance people. Some of these issues go beyond, well, FIC falls under our portfolio, as it were. But can you just go a bit slower? Because dealing with aspects.
Sorry, I'm aware. Thank you.
Well,
for that. I'm aware of time
and remember,
constraints.
whatever you think about the 15 minutes allocated to you, I've no doubt when you go to international conferences, you can fly to the other end of the world in your sector and get 10 minutes. It's fine. We're going to read every little sentence, every comma and full stop of what you do before we do anything about processing clause by clause. That you can be assured of, right? Go ahead, please.
Okay, so thank you. So if that's what you want, so this is back to the first slide, which just goes through the detail of, so at the moment, how they've done it was Treasury suggested, the initial suggestion was to make every single nonprofit in the whole country mandatory to register with the Nonprofit Directorate. At the moment, as you might know, registration with the Nonprofit Directorate is not compulsory. It is an enabling kind of thing, and it's certainly not compulsory. So this was a huge shift, and this is what invoked the huge response from the sector, as you may have seen in various places. So our contention and our belief is that although we are glad that the class of nonprofits, which now has to be registered with the Nonprofit Directorate under this B version of the bill, is a limited class, and in fact they've defined it as organizations which are either conducting nonprofit activities cross-border or which are transmitting funds cross-border, we still think that the way that the NPO Directorate is currently not functioning, as opposed to functioning, underfunded, not credible, data systems, my colleague will deal with those kinds of details in a little bit later, means that it would be better, in fact, neater, to, instead of creating that category of nonprofits that mandatorily must register with the NPO Directorate, to just add, and this is my definition of a cross-border nonprofit entity. It lines up with the latest Treasury definition in the green block of the organizations which are considered to be those most at risk of being abused by those involved in money laundering or terrorist financing. And then instead of putting this whole shebang of organizations in a mandatory registration under the nonprofit, and in fact having them lost in the great crowd of organizations that are already registered under the Nonprofit Organizations Act, that instead we create the specific defined class of organizations inside the FIC Act. There's in section 76, there's a provision where the minister can by gazette just add to a list of reporting institutions, persons likely to be used for money laundering, but if it's not appropriate to make them accountable institutions. And this is our suggestion of a neat way to resolve it. Please, if you want to interrupt me with questions, if I'm still going too fast, let me know. So these are just the these bullet points are just the obligations that are or the results of following this track of making these sorts of nonprofit organizations reporting institutions under FIC instead. And it's all the kinds of things, the kinds of oversight and being able to stop suspicious transactions and put up the red flag of alert that one actually wants to see if there are abuses of this kind of organization. And as I've said, the advantages of putting it under FIC as opposed to under the NPO Directorate is you've got a targeted separate list of these sorts of organizations. and it doesn't rely upon or possibly break the NPO Directorate and its systems. Is that a bit clearer? Are you happy for me to proceed?
Yeah, well, it's not just me, it's the committee. We will take questions at the end in terms of the program, but you're being fine. Thank you.
Thank you. Okay. So just moving on from that, there are one or two other details that haven't been picked up in the B version of the bill, which we think are still important. And one is that they haven't considered how on earth foreign voluntary associations which are operating in South Africa and which might fall into this class of organizations that need to be registered will actually legally find their way into our system. And that is because a foreign voluntary association, an unincorporated entity that happens to be working in South Africa and that passes certain limits, as opposed to just giving out money or holding meetings, there is currently no requirement for them to have a registration or a legal identity locally. Under the previous Companies Act, the 1973 Companies Act, the wording was that, in fact, unincorporated associations which passed the point which is stipulated very clearly in Section 23 of the Companies Act for when you need to have a local registration, that those could in fact be registered as non-profits. It would have been as external Section 21 companies under the old Act, now as external NPCs. And we just propose this is a detail, and we propose that this is adjusted, as we've said in our detail of our submission, so that this particular legal loop is closed. The other legal aspect which we think is important, and particularly important in the non-profit sector, is that the way the NPO Act currently defines the board or those fiduciaries or the governing body is not aligned with the way that group of top fiduciaries, the board, the directors, the trustees, are defined under the Companies Act or the Trust Property Control Act. And in fact, there's a misalignment in the NPO Act in that it refers to executives, which is a completely another crowd of people. This is something we've already made submissions about to Treasury in the previous rounds, and we've said we think this definition needs to be aligned. But I think because of time constraints and they just had too much in their heads, they haven't made this shift. It's not a big thing, but we think it's an important thing to make sure that the same group of fiduciaries across all three kinds of organizations is being held accountable and their details are being recorded. Then I hand over to my colleague Anne to deal with a central part of our submission called Not the NPO Directorate.
Good morning. Good morning. Thank you, Nicole, and good morning, everyone, and thank you, Mr. Chairman. Not the NPO Directorate is our battle cry at the moment, because it's always been under-resourced, it's always been battling, and now we're looking at even a higher level of responsibility. The NPO Directorate as itself should be independent, but under the DSD, we feel its wings are clipped to a certain extent, and they seem to lack the confidence to fly. And we are pushing for this to be considered seriously, even though it's not part of the bill, but it does impact on the success of the bill. We've come up with a whole wonderful lot of legislation here, but the implementation and the management thereof is what really becomes the shining star. So there's a list of our concerns there. I don't need to read them out to you, but it's one of the things already. There's over 270,000 registered organizations. That's a high number. We're not sure if there's sufficient staff and resources to manage that. The other thing, 61% of the nonprofits at the moment are non-compliant. And that is a big worry, because how do we now monitor and mitigate any of this money laundering or financial terrorism if we can't even manage what we've got at the moment? So serious consideration. We've heard from Treasury that there is money in the budget to strengthen and build up the NPO Directorate, but will that be under DSD? And this is where we think the problems are occurring. Next slide, Nicole. So if the MPO Directorate, then the prerequisite for limited ambit compulsory registration as an MPO would be that the MPO Directorate internally kept this list of organisations separate from those of voluntary non-profit registrations so that they can be separately tracked. Now, this would be the subset of non-profits that are at risk. The MPO Directorate systems are substantially upgraded and reinforced for security, stability, and to allow data required to be found and extracted. The MPO Directorate is relocated as a structure independent of the DSD, and that the staffing and skills at the MPO Directorate are overhauled and upgraded, that they have legal and audit skills. These will become an essential aspect of their work. So an independent MPO registrar, how will this look? There are models around the world, and I believe that the MPO Directorate has looked at the Charities Commission and similar independent setups around the world. So there is an understanding of how this can work out of a ministry per se. So there we have our notes there for you to read. And as you say, you'll take everything that we've said and take it seriously. And we really thank you for this opportunity to hear our particular cry. We believe that the DSD has a heart and soul for the betterment of humankind, whilst an MPO Directorate needs to have a clear head and strong administration focus. Thank you.
Thanks, Anne. So just to say that we think that going into this whole process, those who drafted the bill had an inaccurate take on the NPO Directorate, where it sits, how it is, how it doesn't function. There was certainly surprise and alarm in the meetings when the details of the various levels of dysfunction were articulated by us. And so, as Anna said, it's not part of the bill, but it is deeply linked to the issues that are in the bill. In that, we think in terms of enforceability, that there needs to be a huge upgrade of the NPO Directorate if that limited compulsory registration is to stay with them. And
can you please round up? You're at almost 15. Go ahead. Yeah, you can round up. I mean, you're on the next minute.
Yes. And in fact, yes, I see. I started my timer a bit late, but I am out of time. But thank you so much for hearing us.
No, you can finish. Another minute or two is what I'm saying. It's fine.
That's okay. As I said, the details of the proposed changes are in our written submissions that have been made. And we really appreciate this time given for our voice to be heard on this particular issue, which we think is crucial in terms of because remember, it's not just about passing a bill now, it's whether it can be policed, whether it will actually work, and whether the FATF review that occurs in, I think, 2 years' time will show that any of this has been implemented. And our largest concern is that the NPO Directorate, as it currently is under DSD, will not be able to implement these provisions in any way that is useful in terms of constraining the financial issues which it seeks to constrain. And that's us, over and out.
Thank you.
Thank you, Chair.
Thank you, Helen Suzman Foundation.
Hi, everyone. Let me just share my screen. Apologies, it's not currently sharing. I'm just trying to get it done.
Do you want to speak to it in the meanwhile, because we've got the text?
If you've got, sure. You can
try to do that simultaneously. I mean, you people are quite good at it at your age. So in the meanwhile, let's go ahead. We've got the text. Yeah.
That's a bad assumption on my behalf. I'm letting my generation down, clearly.
It's enabled, Chelsea, so go.
Oh, great.
I can see it's enabled.
Yeah, it should be enabled, and yet it's not actually sharing for some reason.
Yeah, we can't see it on the screen, but we've got it on our computers. Excuse me. There it is. Please go ahead.
Perfect. Thank you. Sorry.
Okay.
Can you see it?
Yeah.
Okay, great. So thank you for this opportunity. And my name is Chelsea Ramsden. I'm the Senior Legal Researcher at the Helen Suzman Foundation. And I'm joined today by my colleague, Anton van Dolsen, who is the Legal Counselor at the HSF. So the HSF, particularly as a non-profit organization ourselves, recognize the importance of having an efficient and operative governing legislation. With this in mind, we wish to contribute to the amendment of this act as it performs a vital role in society and within the political arena in South Africa. It is crucial that the relevant governing legislation provides a suitable and practical framework then for their functioning. The HSF has made written submissions on the General Laws Amendment Bill, as well as to the Department of Social Development on their Non-Profit Organization Amendment Bill. And as we've asked for in our written submissions, given the very short public time that was given for commentary on this bill, we would like the other submissions to be taken into account as well. They are linked in our written submission that was sent to you. Sorry, I'm just struggling to see my screen, so I'm not too sure which slide I'm on. There we go. So the preliminary issues, the HSF understands the urgency with which the committee is trying to implement the Financial Action Task Force recommendations in order to avoid grey listing, and we understand how important this issue is. However, as the amendments to the NPO Act will have significant impact on these operations and the activities of many NPOs and NGOs, public consultation in this process cannot be rushed. We note that the public was only given 4 days over a weekend to make submissions on this new version of the bill. Since there have been substantial changes from the previous version, we argue that this probably cannot be considered sufficient time in order for there to be proper public consultation. Next one, sorry. Ooh. So we raise two main concerns. The first is the irreconcilability of the General Laws Amendment Bill, the B, this version, with the NPO draft amendment, the draft NPO amendment bill. And the second one is regarding the Department of Social Development. So with regards to the irreconcilability of the General Laws Amendment Bill B and the draft NPO bill, the HSF is concerned that these two processes are running simultaneously and concurrently, but they're being run by different departments. One by the Standing Committee on Finance and the other by the Department of Social Development. This is neither strategic nor is it an effective manner to make amendments to such an important act. And this can be highlighted in the contradictory amendments suggested in the two bills. The General Laws Amendment Bill B requires registration of NPOs in two instances. First, the donations, when donations are made outside the border of the Republic, and second, where certain listed activities are conducted or occur outside of the Republic. So the NPO bill, amendment bill, then provides for somewhat different registration requirements. In Section 2F, the object of the Act will be to facilitate foreign NPO registration. In Section 12.1, it provides for voluntary registration of NPOs. And then in Section 12.5, it provides for the mandatory registration of all NPOs who wish to operate within the borders of the Republic. So not only are the requirements between the two amendment bills contradictory, but the NPO Amendments Act itself is contradictory. So although this is a marked improvement from the blanket one-size-fits-all NPO registration requirements, the HSF is unsure how these amendments from both of the bills can be read or implemented together, and this will create significant uncertainty going forward. This is of particular concern, considering that the General Laws Amendment Bill B intends to introduce an offence for the non-registration of NPOs who are required to register in terms of the Act. The second one is, our second concern relates to the department, sorry, we skipped one slide ahead, but relates to the Department of Social Development. We submit that in terms of international standards, and as alluded to by the participants prior to us, the Department of Social Development shouldn't house the registration body. First, the registration body needs to be independent from a government department, and it needs to include representatives from civil society. This means that to ensure the independence, the members of that new registration entity shouldn't be appointed by government or nor through its discretion. And this would meet international standards as well. However, the HSF submits that if the committee persists in using the registration body within the departments of housing the registration body within the Department of Social Development, the department does not have the administrative capacity in this regard. The department's website, when I checked today, lists that there's currently a backlog of 6,041 registration applications for MPOs, with a processing time of between 112 to 113 days, respectively. We also note that the FATF report provides that even with MPOs currently registered, the department doesn't monitor or investigate the financing of terrorism, and it doesn't have the capacity to do so. We see that the amendment suggested in terms of this bill is to section 13, is that it will deem MPOs registered unless or until the director has given notice. This is if implemented, this will not result in any higher scrutiny or investigation into the financing of terrorism, because at that point, there is no capacity to investigate or to monitor it. We also note the previous responses that the problems of capacity will be solved through the budget process. But we submit that given the current budgetary constraints, this is highly unlikely to be achievable. We therefore submit that it is unclear how the suggested amendments will achieve what they propose to do, as well as how they propose to meet the FATF recommendations that we are required to meet in order to avoid grey listing. I realize that was a quick presentation, and I apologize for the lack of technological expertise on my behalf, but I would like to check with my colleague Anson van Dolsen if he has anything to add.
Thank you. I'll be very brief, just one addition, and that is to support the suggestion which was made by NGO Law, the presentation before us, where it took the route of suggesting that FICA be used in order to keep an eye on certain NGOs. And I think it's a much more sensible approach. As my colleague has mentioned, the Department of Social Development simply does not have the capacity to police an act of this nature, what is proposed. And that including it in the FICA arrangement is a much more sensible and effective manner of dealing with the problem. So that's the only additional comment I would like to make. Thank you.
Thank you. Are you done? Yeah.
Thank you.
Well,
yes, we are. Thank you very much for the opportunity, and everything will be in our written submissions.
Yeah, no, obviously, you don't have to overthank us. It's your responsibility, not your duty, not your duty, your right. Sorry, your right to be here. No, you have to apologize for the glitches we have technologically. I was just saying I thought you'd be faster, but that's fine. That's not an issue. It's not germane to the content issues we're dealing with. So, remember that you will have a chance to reply. And indeed, you come back on Friday if you so choose, and we'd like you to hear what Treasury has to say. You can reply to them. So you'll have plenty of time. I'll respond later, as I'm sure other members might want to, on the 4 days you had, as you say. Okay, let's go to the next submission, which is on the agenda. It's Cause for Justice, and then COSATU after that. Thank you.
Thank you, Chairperson. Let me just share my slide presentation. Share. You ought to see it now. There we go. Start from the beginning. Can everybody see my shared screen? Thank you, Nicole. Good morning, Honourable Chairperson, members of the committee and other attendees. Thank you for this opportunity to make oral representations. My name is Liesl Pretorius and I'll be representing on behalf of Cause for Justice. Just an overview of our submissions. We will look at the background to the Cause for Justice, our interest in the bill, the need for adequate public participation in the legislative process, the need for and the justification of legislative intervention, certain improved proposals in the current version of the bill, certain problematic proposals in the current version of the bill, and finally our recommendations. Let me just move this along. For the sake of time, I'm not going to go into all the detail on each slide, just mention our most salient points. Cause for Justice is a non-profit human rights organization, and as such, we will be directly affected by any amendments proposed to the NPO Act, and we will only be making submissions in respect of those proposals that are relevant to the NPO Act. Much has already been said about the need for adequate public participation, and similarly as NGO law, we concur with the comments made by the Honourable Chair this morning. The period for public comments was inordinarily short, and we are all aware of the constitutional importance of adequate public participation. We are especially concerned that they might be stakeholders directly affected by the proposals that are not even aware of the B version of the bill. And under the circumstances, we understand the urgency of the process, as various other stakeholders have already commented, but we would request the committee to seriously consider whether to grant an extension for call for comments for those NPOs or organizations, stakeholders who become aware of the B version of the bill a bit later, if they can obviously justify why they haven't commented before. This will be the bulk of our submissions. We will look at the need for and the justification of the legislative intervention. Cause for Justice does focus on the advancement of constitutional justice in South Africa. So this is why this is a very important issue for us. The amendments proposed to the bill will only be necessary and constitutionally defensible if actual and sufficiently important problems and or legislative gaps exist that are not adequately addressed by existing legislation. And if the proposals contained in the bill are able to successfully address these problems and gaps without enabling unjustifiable violations of fundamental rights. As numerous other stakeholders have said, Cause for Justice similarly acknowledges and agrees that preventing money laundering and combating terrorism financing is a legitimate and necessary government purpose, and it serves the public interest. And it is vitally important to avoid grey listing, because it will have a very detrimental impact on the well-being of the Republic and its people. And in this regard, we welcome and support constructive efforts to address these serious social ills effectively and proactively. And we note that with gratitude, the improvements that have already been made to the bill. We emphasize that the non-profit sector serves millions of South Africans through doing good public benefit work. And we would recommend that legislative amendments that put additional pressure on this already overextended and under-resourced sector must be avoided. To answer this section, to see whether there is a need for legislative intervention and whether it is justified, we will consider two critical preliminary questions. Now, as we are aware, the bill seeks to amend certain sections of the NPO Act, make registration mandatory for now a limited subset of at-risk NPOs. I will sometimes refer to them as affected NPOs. And these NPOs will be required to comply with the provisions of the Act, the existing ones, as well as any new provisions or amended provisions. And these affected NPOs will be those that make donations to individuals or organizations outside the Republic borders, or those that provide humanitarian, charitable, religious, educational, or cultural services outside the Republic. This is still a drastic change from the current status quo, from voluntary registration and compliance to compelling it against the threat of administrative sanctions. And it will impose legal obligations on NPOs, the ones that are affected, the governors and their office bearers, and limit their constitutional rights. So to ensure that these proposed amendments that will be limiting constitutional rights are necessary and constitutionally justified, we need to answer two questions. Firstly, what is the likelihood of the legislative amendments actually achieving their purpose? And secondly, even if they do achieve their purpose, do there exist less restrictive means on achieving this legislative purpose, as one does not want to unnecessarily infringe on constitutional rights? The first question is, what is the level of assurance that making a registration under the NPO Act compulsory for the affected limited subset of NPOs will in fact translate to preventing money laundering enterprises in the NPO sector? It is necessary, as I said, to ensure that the proposed amendments will translate to effectively addressing money laundering and terrorism. Otherwise, they would serve no legitimate purpose, and the whole exercise effectively will be in vain. And an important objective is avoiding grey listing. So if the proposed amendments, in fact, do not translate in the end to avoiding grey listing, when the FATF do their review, likewise, it will be in vain. So we request the committee, and we are very aware of the time constraints, to thoroughly investigate whether whatever is proposed will in fact translate into effectively combating the social ills. And for this reason, any evidence presented for why the specific proposals should be adopted must be scrutinized effectively. And if there is time, even independent experts should be asked their comments on whether these arguments and evidence are sound. The oversight and support capacity of the NPO Directorate has already been mentioned. An important and central aspect of any successful NPO registration and regulation system is the support and oversight that will be provided by the NPO Directorate. And there has been assurances from National Treasury and the Financial Intelligence Center that DSD will be, and the Directorate will be capacitated. But similarly, as we noted by other stakeholders this morning, we remain very concerned that the NPO Directorate and DSD will be able to deal with the workload. There's already a backlog, as has been mentioned this morning, and the issue is that even if the proposed amendments are good in law and they are practically able to address the identified social ills, but wherever this function is situated, that organ of state or institution, they are not able to proactively and effectively implement the proposals, the FATF recommendations will still not be complied with, and grey listing will still not be avoided. And we think that NGO law has made sound recommendations in this regard about who should provide oversight on this function. Turning back to the limitations analysis, it's very important to note that proposed legislation limiting constitutional rights will only be unconstitutional if it does not achieve the purpose for which it was made. And this is because of the limit. We refer to the limitations clause in section 36 of the Constitution. And the limitations clause include various factors that need to be considered. The chairperson has noted that the committee will consider the detail of the submission, so I will not unnecessarily belabor the point. But it's important to say that a limitation on constitutional rights, which the proposed legislation obviously implies, must be reasonable and justifiable. And in order to determine that, factors A to E must be considered, and this necessitates a very delicate balancing exercise, properly called the proportionality test. And that requires all 5 of these factors to be read together. And the purpose of that is to establish whether there's a rational relationship between the limitation of the rights and the purpose of the limitation, taking into account the 5 factors. The factors, they are set out here. Factor A, the nature of the right. The rights in question that we are particularly concerned with is section 18 and section 15 of the Constitution, very important rights. Obviously, the purpose of the limitation is important, combating money laundering and terrorism financing. The nature of this and extent of the limitation, this will require an examination of the severity of the limitation in limiting the right in question. So to answer this, the committee will have to look at determining the relationship between the limitation and its purpose. And our courts have established that the more substantial the inroad is into the fundamental rights, the more persuasive the grounds for the justification must be. And if we consider the possible detrimental effect of compulsory registration on affected NPOs, many of most who will be completely innocent of money laundering and terrorism financing, this factor already raises, in our minds, serious doubt as to whether the proposed legislation in its current form will pass this test. Factor D concerns the relation between the limitation and its purpose, and this actually establishes the proportionality principle. In other words, whether there's a rational relationship between the limitation and the purpose. And the proportionality test consists of two elements. Firstly, it must be determined whether the limitation will achieve its purpose. And secondly, whether there is a rational relationship between the limitation and its purpose. And in respect of the first element, if there is no convincing indication that the proposed legislation will in fact achieve its purpose, it cannot meet the first element. And secondly, and back to the first element, if whoever does the oversight.
Slow down a bit, please. Can you slow down a bit? Okay. We're not lawyers. None of us is, and you're going very fast. Yes, we can read what you're saying, but you're not helping yourself. Look, your colleagues haven't, your comrades or whatever, haven't taken their full 15 minutes. So, if need be, I'm sure they don't mind. You can have a bit more latitude. The committee has allocated an hour to 4 of you. We're at 10:44. Matthew is very good in managing time, although he's getting a bit wobbly there, but that's fine. We can more or less predict what he's going to say. You can please slow down. We're not lawyers. Yeah, we can read. We will read the stuff. And Frank Jenkins, are you here? Frank? Oh, lawyer.
No, Chair, he's not here. He's held up in another meeting, but he will be here.
Is there anybody from the Legal Services Unit here?
No, Chairperson.
Fine, we'll give them this recording, and they must also help us independently. We can't have Treasury tell us what's legally sound and what's not, and in what sense, if at all, the constitutional rights have been trodden on. I personally, okay, let's not go there. We'll let members speak, and then I'll come in at the end. Okay, go ahead, please.
Thank you, Chair. I'm just going to backtrack. So we're at at factor D, the relationship between the limitation and its purpose. And
can I alert you to this, right? Can I explain to you? We are not lawyers. Okay, we will have to refer all of this to Frank Jenkins and his team. Okay. On those issues, it's not a policy issue. It's a legal issue. It's a constitutional issue. Is what you're saying legally sound or not? Okay. And then Parliament will advise us. Members can give their own views. That's fine. I have no problem. But ultimately, it's not we. It's not a policy issue. It's either constitutionally sound or it's not. And if there's a difference between you and Parliament and the National Executive or National Treasury, it'll go to a court, which you're free to do. Okay. But we're not, colleagues, I want to urge, we can act as lawyers and flaunt our lack of legal skills, or we can deal with the policy issues. Now, some of the aspects you and others are dealing with are really for the domain of the team in the Legal Services Unit. But you go ahead, and members are not stopped from saying what you are, what they want on legal issues. I'll keep my distance because I'm not a lawyer. I don't think I fully understand the issues, and I have no view about whether it's legally sound or not, what you say. Go ahead, please.
Yes, Chair,
you will not divide your time. You can go ahead. Yes, please do.
Thank you, Chair. I just want to mention, because these things it also has an impact, on the practicality of the bill, which I think it informs policy, or should. I think let me just get back to my place. The second element is that even if the bill achieves its purpose, it cannot limit rights more than it should. And that will get us back to the current proposal in the Act about what is the limited subset of NGOs, of NPOs that will be required to register. And we need to consider whether that is overbroad or over-inclusive, because if it is, it would be unconstitutional. Yes, as you said, Chair, you will refer to your legal services. We just want to state that our submission is that we do not believe that in its current version, the amendments proposed in the bill will pass constitutional muster. Factor E of the second critical question that needs to be just considered is whether there exists less restrictive means to achieve the purpose of the legislation. So So even if the proposed amendments are good measures or solutions, one does not want to infringe on existing rights and freedoms of NPOs and their governors and their office bearers more than is absolutely necessary. So if there's a less restrictive means to achieve the purposes of the bill, that should be preferred. Now, the NPO Act is a law of general application, and it does affect the right of NPOs. So their rights can be limited in a reasonable manner and a justifiable manner. But registration is still required of all NPOs that make donations to individuals or organizations outside of South Africa's borders, or provide humanitarian, charitable, religious, educational, or cultural services outside of South Africa's borders. So even that the subset, the NPOs that need to register, that subset has been limited. But even still, it must be ensured that this subset is not overbroad, so that the rights of NPOs are still not restricted any more than is absolutely necessary to effectively achieve the goals of preventing money laundering and combating terrorism financing in and through the NPO sector. And as I said, we are immediately concerned that this kind of category is very broad. Many religious organizations, for example, routinely and as part and parcel of practicing the doctrines and tenets of their faith and fulfilling their religious mandate as they see it, will do these things. They will make donations to individuals, organizations outside of South Africa's borders. They do provide humanitarian and other services outside of South Africa's borders. So practically this means that many, if not most, religious organizations will be compelled to register and comply with the Act. And this will place an immense administrative and financial burden on such organizations and expose them to administrative sanctions, which are not defined in the Act or in the current proposals, for non-compliance. This additional burden may cause these religious organizations to cease operations, which necessarily will mean the loss of good and essential public benefit work being done. And because we reiterate that these organizations do tremendous good work that impact millions of South Africans and people abroad. And also that these organizations take a lot of pressure off the state, and particularly the Department of Social Development, by providing welfare and quasi-welfare services. So if the proposed amendments will force these organizations to cease operations, much harm will be suffered by South African society and even communities of abroad. So we urge the community to scrutinize the proposed wording to ensure that unnecessary burden is not placed on these organizations, threatening their existence, and that their rights and freedoms are not infringed upon, that they remain protected. So in summary, for this section, these are complex issues and they require proper consideration of the constitutionality of the intended implications, also of the unintended consequences. As I said, our conclusion is that the version of the bill as it currently stands will not pass constitutional muster. We also note that there are marked improvements to the bill, and we are very grateful for these. Most notably, the abandoning of blanket mandatory registration of all NPOs, abandoning of criminal sanctions for non-compliance, and also limiting the circumstances in which an NPO may be required, in other words, compelled to alter its constitution. This offers greater protection of religious freedom rights. But however, there are still problematic proposals. We are concerned that there will be far-reaching detrimental consequences of the proposed additional compliance burden, even if it only affects this limited identified subset of NPOs. We note that the FATF recommendation 8 says that it is unnecessary to impose specific licensing or registration requirements for counter-terrorist financing purposes on NPOs that are already registered with tax authorities such as SARS in South Africa, or monitored in the context of qualifying for favorable tax treatment, for example, PBOs. So if NPOs that are registered as PBOs with SARS can be excluded from this category of deemed at-risk NPOs.
Can you begin to round up, please?
Thank you, I shall do so. This will immediately lessen the burden on the state and NPOs without falling foul of the FATF recommendations, and it will simultaneously prevent numerous religious organizations from being subjected to additional burdens. And as mentioned, we do have concerns about the subset of identified NGOs. At a cursory glance, we think it is still much too wide Our comments on specific clauses. Amendment of Section 2, objects of the Act. As said, we do not support.
Yeah, but that we can read. I mean, you've taken, well, if you clip out the time I intervened, you've taken about 17 minutes. And
Okay.
I'll cover the ground. You know, you say that these constitutional issues are important because they influence policy. They provide the parameters for policy. Obviously, they link to policy, but it's easier to deal with this because we can look at the clause and see what you're doing, and we will do exactly that. And then we can do a table in any case of all the amendments you propose. All right, can you round up, please, in 30 seconds because you have to move on.
Okay, Chair, I will not look at this. I will just go to our recommendations. Preferred option, keep voluntary registration completely voluntary. Yeah. Alternative option, have a constitutionally defensible, appropriate, limited subset of NGOs. And then there's one thing about administrative sanctions. The Act now mentions, or the proposals mentions, prescribed administrative sanctions, but this is not specified in the legislative text. And Parliament cannot, approve legislative text that the executive can at some later stage go give content to or decide, because that would be unconstitutional unless the proposal, the amendments also say, well, a specific person, designated official, is authorized to, to determine these prescribed administrative sanctions in regulation. So that would possibly cure that constitutional defect. So those are our recommendations, and that's just a summary. Thank you so much, Chair.
All right, Kusatu, over to you, Matthew.
Okay. Yeah. Good morning, Chair. Good morning, members. Let me just share quickly our documents. Okay. Sorry, Chair. Can Kuleleko just share it for us? I seem to have not downloaded the correct format, Chair.
Matthew, that's shocking, but anyway.
My apologies, Chair.
I'm going to report you your GS. Okay, go ahead.
As you said, Chair, I'm aging disgracefully.
Yeah, you took 42 seconds, I think, more than you should the other day. Your 3-minute reply yesterday. Okay, let me not needle you. Go ahead.
No, thanks. So maybe Kuleleko can just go to the presentation mode. We can just go to the yeah. Okay. No, thanks. So I think, Chair, just to say thanks as COSATU and also our affiliate SACTU, the South African Clothing and Textile Workers Union. We do welcome the tabling of this bill. And I think we also want to welcome the additional amendments made by the National Assembly during its processing of the bill. We think these are going to help us quite significantly. So we think, Chair, the bill is a positive step forward by government to address gaps and weaknesses in our existing laws, which we feel hamper the nation's ability to deal with real problems of money laundering and terrorism financing, and of course, Chair, to ensure that we're able to try to avoid the consequential and quite devastating potential grey listing. And whilst as COSATU and SACTU we do support the bill, we are concerned that there are some instances where we think it is still not sufficiently clear enough with regards to the definition and the disclosing of beneficial ownership, which has really been our focal point. Next slide. So, Chair, I think we want to just also say as COSATU and SACTU, we do support the bill's objectives. We have seen the real consequence of treating corruption, state capture, tax evasion, money laundering, and the financing of terrorism with kid gloves over the past few decades. We think we're only now beginning to turn the corner as a nation in the fight against these pandemics. And this corruption state capture, Chair, to state the obvious, has had real consequences for the fiscus. We've lost billions of rands to criminality. We've had to spend billions on bailing out SOEs, which have been collapsing, on municipalities because of these issues of corruption. We've had to divert funds, which could have been used to pay for public services that workers and the poor and the economy need. It's forced the state to raise taxes, further bleeding the salaries of workers and suppressing economic growth. We've seen many workers have lost their jobs, haven't received their wages, and have been denied increases as a consequence. And of course, the consequential budget cuts have further stifled an economy still recovering from COVID-19. Next slide. So, Chair, I think we also appreciate that we have to deal with the United Nations, which has identified a framework for the requirements for member states to contribute towards dealing with these global threats of money laundering, of terrorism financing. And the reality is, if we don't do so as a member state, we will be grey listed. And this will come with real consequences, not only administrative restrictions, but more critically for us as a trade union movement, it will make it much more difficult to attract domestic and foreign investors who will be reluctant and at times will be actually prohibited from investing in a market which is being grey listed. So these are pension funds from overseas, etc. And this is a scenario, Chair, that workers can't afford. We're struggling with a stagnant economy, with an unemployment rate of 44%, of a dwindling manufacturing industries, of a flood of cheap imports, capital flight, etc. So we can't afford any further blows to the economy. Next slide. So, Chair, we know there's been a lot of issues that are saying, well, these are issues of privacy. Some of the colleagues in the private sector have raised this. We're not convinced. We think that the enhanced transparency provisions in the bill, motivated by a possible grey listing, we think they're rational. It's about recognizing that corporate activity has a wide social impact, which is why the Companies Act already grants strong rights of access to a broad range of company information. And this was also highlighted by the Constitutional Court in 1996, where it said the establishment of a company as a vehicle for conducting business on the basis of limited liability is not a private matter. It draws on a legal framework endorsed by the community and operates through the mobilization of funds belonging to members of that community, in particular to workers' pension funds. Any person engaged in this activity should expect that the benefits inherent in this creature of statute will have responsibilities. These include, amongst others, the obligations in law of a proper disclosure and accountability to shareholders. Next slide. So, Chair, just in terms of the definitions, we feel quite strongly as COSATU and SACTU that a definition must define a beneficial owner as should always be a natural person, nothing else. With reference to a natural person, only the first layer of ownership might be pierced, and the actual owner might not be fully revealed if the wording isn't sufficiently tight enough. So we do want to welcome as COSATU and SACTU the amendments made by the National Assembly to address our concerns on the need to ensure all layers are pierced to find the actual natural person who benefits from the shares, and that the definition of beneficial ownership states includes this, but is not limited to a natural person. It is critical that our laws utilize the single broad definition of beneficial owner within the Financial Intelligence Center Act, and secondary legislation shouldn't seek to alter or to weaken this definition, because this will introduce uncertainty and create loopholes that can be exploited. Sorry, next slide. So, Chair, in terms of the publishing of information, the bill attempts to provide beneficial ownership data access for enforcement agencies by mandating the creation of various registries, including Clause 53, a beneficial ownership registry for companies within the SIPs. We note, and we're a bit disappointed that the bill doesn't seem to seek to make beneficial ownership registers publicly available. It's not clear in that regard. The bill does include a reference in Clause 53 to making annual returns available electronically, but it isn't clear that this would mean that such annual returns would then be made publicly available. And the FATF has listed the requirement of making beneficial ownership information publicly available in the guidance on transparency and beneficial ownership as part of understanding the risk associated with legal persons, and in particular in respect of company registries. So we feel, Chairs, COSATU and SACTU, that by making beneficial ownership information publicly available, it helps unions, shop stewards, workers, civil society, journalists, etc., NGOs, to continue to assist in the fight against tax evasion and corruption. And this also will help to effectively implement a beneficial ownership regime, not just for us to go through a tick box process. So, Chair, we feel by not making registers publicly available, we run the risk of such registers being stuck on a hard drive or servers in some department somewhere and not getting the scrutiny we would want to see being achieved. This would, sure, it'll achieve the legal compliance of collecting information, but it wouldn't necessarily help to win the fight against tax evasion or corruption. So we would have preferred some provisions in the bill, but we do acknowledge Treasury's commitment during the National Assembly's processing to provide commitments in the regulations to ensure that there will be provisions to ensure public access to beneficial ownership registries and to require companies to proactively disclose annual returns. So we support information about trust beneficial ownership being made available publicly. And this ownership records at the master's offices should also mirror how company records are envisaged in the bill to be published and made available annually and when updated. Next slide. So, Chair, we know there's been some concerns around the issue of personal data. And some may raise concerns about personal data protection and privacy laws when responding to our call for public beneficial ownership registries. We think that in South Africa, we've got the privacy and data protection concerns are given legal effect through the POPIA. And we feel sure that this act shouldn't be used as an excuse to block the publication of beneficial ownership data. Sections 37 and 38 of POPIA list a number of grounds on which the processing of personal information is not a breach in the processing of conditions in the Act. Part of these grounds include when the public interest outweighs the interference with privacy rights, the prevention and detection and prosecution of offences, fostering compliance with legal provisions, and to protect the public against financial loss due to dishonesty or malpractice. So we feel that any of these grounds could be relied upon to substantiate publishing beneficial ownership data when concerns are raised with regards to privacy or data protection laws. Next slide. So just getting towards the end here, in terms of the updated records, so in clause 55, the bill proposes the addition of two subsections to section 56 of the Companies Act that would require the filing of additional notices within a prescribed period. These proposed additions introduce important reporting obligations for companies in respect to the beneficial ownership information. However, these provisions do not provide for the disclosure of or access to this information. While we cannot know what the prescribed period is until it is prescribed in terms of the Act and regulations, it seems clear that it'll be more regular than the annual requirements because the annual requirements are already provided for in law, and we would want to argue that it should be at least quarterly. These new sections are commendable, Chair, and we feel it's going to enable the SIPs to collect information on beneficial ownership throughout the year without simply having to wait for annual returns. However, there is no provision for disclosure of this information or access to that information, so we would recommend some additional provision be inserted in the bill or at the very least in the regulations. And then just to the last slide, Chair. So in conclusion, Chair, I think we just want to say as COSATU and SACTO, I mean, we've appreciated this bill's been processed in a very rapid space of time. This is not ideal, but we think we have to, for obvious reasons, meet the time frames. We think there has been some significant revising of the bill in the National Assembly, which does address a lot of the concerns. And as a whole, as COSATU and SACTO, we do welcome the bill and its provisions as a positive step towards ensuring South Africa remains in compliance with our international objectives and also to critically avoid a grey listing. The time is very, very tight. We believe that the provisions in the bill, including those to ensure greater transparency of the actual owners of companies, will help to address serious gaps in our existing laws and to further capacitate the state, including the FIC, the Auditor General, SARS, to tackle corruption and tax evasion, money laundering, terrorism financing. We feel, Chair, that when company ownership is opaque, then these crimes will thrive. So we need to address these issues. And Workers' Chair cannot afford for government to be soft on crime at any instance, in both the public and also critically the private sector. We feel that if we fail to deal with these cancer eating at the heart of the state and the economy and our fabric, the consequences for us as a nation will be quite dire. So in conclusion, Chair, as COSATU and SACTO, we support this bill. It's important. It is critical that the gaps we have identified with regards to the definitions and provisions dealing with public access to company ownership be addressed. If they can't be addressed in the bill because of time constraints, then at least should be addressed in the regulations if we're going to meet the progressive objectives of the bill. So that's our presentation in a nutshell, Chair, and apologies for not being able to share today. Thanks very much.
Thank you, Matthew. You've recovered your credibility, having used only 11 minutes. Okay, over then to members. Who's coming in? The hands that are up. Dennis, Simon Moletsane. Who else? Okay, for now, go ahead, please.
Thank you very much, Chairperson. Good morning, everyone, and good morning to you. Yeah, Chair, thanks. Obviously, we have a fairly contentious issue in front of us, and there seems to be one big sticking point. And I thought that the presentations today were of an exceptionally good quality, so thank you for the input. And I thought the comment about the octopus on the very first one was most relevant, because we are trying to do a hell of a lot of things with one piece of legislation, and it sets us up a little bit, and this is a concern. And I raised it in my motion yesterday in the House, is that if we try and put together a bill in response to a situation that we're facing with the FATF. And in doing so, we create a bill that is unimplementable and patently and obviously so. It's actually going to be counterproductive. So, you know, if we create legislation that can't be enforced, it's going to set us up for failure, especially because, you know, a cursory reading of the situation is going to confirm that that the law is unimplementable. And I think that's some of the concerns raised across the board. Helen Suzman Foundation, you know, kind of led the charge on that, I suppose, with the most content. But NGO law did, you know, covered it well as well. Is that one of the proposals with the NGOs and the registration is to house it in the Department of Social Development, and you know, that they really can't manage the small role that they have in the process, and now they are trying to take it further. So perhaps Treasury can help me with a couple of things. The first one is to say, what were the changes in the bill? So if you can spell that out for us as members, you know, what was changed between version A and version B. Just detail that, not minute detail, but give us a broad overview so that we can understand what was changed. And then perhaps you can say, because the opposition by the NGOs has been coming from the word go as soon as the draft was published. And so tell us perhaps why we haven't addressed the concerns of the NGOs, because I think they've got legitimate concerns. And there's a general consensus. Again, it was what I mentioned in the motion yesterday, is that there's a general consensus. We want to beat grey listing. We want to do as much as we can to ensure that we are compliant. But you know, we also can't pass fraud legislation. And yeah, I think, yeah, the comment was made again in NGO Law's presentation that perhaps Treasury is too far down the lane now. That was the phrase used, and they can't go back. And I thought that, again, Cause for Justice asked a very important question, saying, you know, are we achieving the purpose? Will this act, this bill, when it becomes an act, will it achieve the purpose that we're setting out to do? Or is it kind of just a blunt instrument that perhaps window dressing even is a better thing to say? You know, is it window dressing to try and show, you know, look how good we are, we're trying to do what you asked, and then the reality is that, and there were alarming facts put before us today. 10-year backlog in NPO registration. I mean, that's really scary. You know, donors to NPOs and NGOs rely on that NPO number to give some credibility. Now, there's a 10-year backlog in registration. There's probably a 10-year backlog as well in terms of ensuring that these things are still legitimate. So I think there's a bigger thing to ask here. You know, now we've got the FRC, which has a certain role to play in terms of keeping records of who's who in which particular zoo. We've got the CRPC that has a role to play. We've got the Master's Office looking after the trusts, and you know, FATF has indicated that that's a problem. And now we want to bring the Department of Social Development in as well, almost replicating structures or processes, probably replicating you know, systems that need to back the thing up. Of course, there'll be numerous tenders going out so that they won't be able to benefit or piggyback off of each other's technology, and it's going to create huge hassles. So yeah, there was a very interesting distinction made between the reporting institutions versus accountable institutions, and a proposal that came out of that as well, which I really think Treasury needs to comment on. You know, rather than you know, reinventing the whole wheel. I thought that proposal that came out of the first presentation was extremely useful. I do want to agree again, Mr. Pretorius, with the issues around public participation and the constitutional imperatives of that, and the fact that yeah, this particular process doesn't look like it's going to stand up, Chair, and really I think Treasury needs to perhaps use us to assist them. And maybe open up a short window as well for some additional public participation, particularly noting version B of the bill and the very short window that was on that. But Chair, you know, noting that it's a very complex piece of legislation, it is an octopus, it's an omnibus octopus, and yet we find ourselves here really facing probably one challenge with getting this thing through. It's one aspect of the bill that's problematic, and I do think Treasury, on the one hand, needs to be congratulated for that, but on the other hand, needs to take the message that's been given to them, because it's across the board. And the reality is, going back, what are we trying to achieve? You know, my mother is an absolute saint. She runs a knitting group and a sewing group for charity, etc., etc. They have a little account that they use to buy tea and cake, and you know, once a year probably a bit of champagne. But Chair, you know, are they required to jump through these particular hoops because they have very low volumes going through that account, and they're certainly not doing international transactions with it? Are they required to jump through the same particular hoop that an NPO is that's generating millions in donations or high volumes of donations, and doing overseas transfers and donations overseas, etc.? You know, this is a one-size-fits-all approach. I'm not sure it's going to work. That's my understanding, Chair. Perhaps we can get more on it. Thank you very much.
Simon. Maletsane, comrade, are you here? Or is he cut off in Kulileko?
You're still here, Chairperson.
Maybe he's having a problem.
Yeah.
He's embarrassed because his comrade objected to my motion yesterday, Chair.
Oh, all right. Well, when he comes in Kulileko, you can include him. Are there anybody? Are there any other hands up? No, I don't see. Okay. Okay. So some of the issues I raise are addressed to Treasury more than the NGOs. Now, Treasury, you're going to give us an initial reply today. Now, you've come across these issues on the NA side, so it's not as if they're hitting you unexpectedly, and it doesn't stop you from answering now. They will give you proper answers, which are more thought out and processed in your department on Friday.
Chairperson?
Yeah, okay, Comrade Maletsane, go ahead.
Thank you. I had a problem with a gadget. I had to change the gadget.
No, I know. You're very old.
Thank you
now.
for your
You can't do
patience.
this.
I just have a question to the Treasury. This bill was given to the Treasury in 2017, and it was only tabled to Parliament this year in June, which makes or put the pressure to Parliament to deal with this bill. What can be the reasons that caused the delay of tabling this bill to the Parliament? Lastly, Chair, is it possible? Is Treasury does the Treasury believe that we will be able to make it to meet the deadline of submission come next year? Thank you, Chair.
Okay, Comrade Maletsane. as I was saying, some of these issues are more appropriately responded to by Treasury. But firstly, my own feelings. Look, this is the first time we're dealing with civil society, and it's our first take on it. There's no such thing as jumping to any conclusions or making any decisions. So I am merely offering my own views as a member of this committee, but also providing some broader sort of guidelines, if you like, to the committee as a whole in my capacity as chair, but none of what I say has to be accepted by anybody in this committee, not least the party I come from. So the first thing is, I think most of us, if not all of us in this committee, are very, very sympathetic to NGOs. And we've been pleading with NGOs to participate more actively in Parliament. Some of us have written about this for years and years and spoken about it. And before 1990, we're involved in the sector of civil society organizations and so on. So we're not going to now, at the age of whatever we are, retreat from that. If anything, now more than ever, the governing party and the state needs NGOs. It is an increasingly failing state, in my view. It's not a failed state, it's increasingly failing. The governing party is increasingly weakened, as the peasants in Mongolia now. There's nothing to hide. Even they know it, right? So, and if you look at the documents of the governing party and also its alliance partners, if you look at what happened yesterday on the streets of the country, the big metros particularly, there's a greater focus even by the governing party, by the ANC, on the importance of links with civil society and the need we have for them to consolidate this democracy, and under the conditions of the 2008 crisis, the crisis that befallen us with COVID, the social unrest of July, floods in KZN, and a myriad other problems we have. So what I would like to ask the NGOs is, you're presenting a view as I see it, one interpretation amongst many that could be made of what you're saying, is that you are being circumscribed and curtailed and restricted and undermined by the state, by the government, by the national treasury. Why would they want to do this? Can somebody, all of you, when you respond, explain why would national treasury want to do this, have something like this done, when it itself is a way of the powerless state, to put it mildly. It's an understatement of our budget and our failure to deliver and get value for money. And they too have been every now and then calling on civil society to monitor spending and what value we're getting for that spending. Secondly, look, can you show us the civil society on the one hand, what is being done here that is not required by the FATF? There are glimpses of it in what you say, but I didn't get it. Maybe you did say it, but I can't get a keen enough sense. And when Treasury replies, can you tell us why you're doing what you're doing and to what extent it's required by the FATF? So both sides are being asked to do that. Now, NGOs are very, very divided, okay, and generally. You don't even have a federal structure. Some of us as politicians have been pleading for this since Sangoko collapsed. So when you say you speak for NGOs, maybe you can tell us a bit about who you are, how many organizations you represent. It doesn't matter ultimately, even if one individual makes a public submission as against powerful business and labor federations and other big fat NGOs, that one individual citizen, if there's merit in what he, she, or they are saying, we have to take it as seriously as an organization like COSATU, which is 1.4 million, whatever its figures are right now. Okay, so basically, it doesn't matter, but it's useful to know who you really are. You talk of yourselves almost as if you represent more, like you say, NPO working group. Now, who do you represent? Which NPOs? Cause for Justice. Who are your organizations or individuals or what membership do you have? It's important just to have a sense, because we should be careful about saying NGOs. Where are all the other NGOs? But it doesn't ultimately, your submission is treated on the merits of what you say. But it's interesting that the NGOs that have surfaced here, apart from the Helen Suzman Foundation, and I've been in Parliament for thousands of years, I don't know you actually, and that may be my fault, but I know many NGOs, and many of you have appeared. Yesterday we had 13 organizations before us on the tax bills. So can I ask whether maybe underlying what you say is a concern that we have a draconian state emerging? And maybe I'm asking a question, I don't know. I have to look beyond the surface of what people say, as you have to do when you look at what I'm saying. Obviously, you're going to try to locate what I'm saying in a context or some other way of understanding what I'm saying beyond my mere words. So you must do the same in respect of me. So what I'm saying is, I can't see why Treasury should want to emasculate or undermine you, or the government would. Be hell of a stupid, really, idiotic to do that. And I wonder if it's not underlying, the underlying concern is a fear that there's a draconian state surfacing, and it's using the FATF requirements for grey listing to contain and curtail trade unions. My own view is that with the weak state that we have, the state isn't capable of doing that. You might want to argue, well, precisely because it's getting weak and the governing party is failing to secure the support it used to years ago, now they have to turn to an autocratic, statist approach to curtail NGOs. Personally, I can't see that really. It's never an issue in all the structures I serve in. So, but maybe that's the way you see it. And that's your right. It's a democracy, my friend. That's your right. I'm just telling you, I don't see it. And let's be clear, you see, we can't romanticize NGOs. If you care to, at least, not that you should, but if you care to, I've written about these things and spoken about it for years. Sadly, NGOs have acquired, I'm not meaning you, the bigger NGOs maybe, or the better known, have acquired similar failings as politicians have. Divisions over power and patronage, use and misuse of funds, overleaning to donors to get support and so on. So it's not like there's a monolithic NGO structure that's prevailing here and that's demanding this. I mean, COSATU, interestingly, it's very powerful. It's not saying the things you do. They've hammered us before, and they have a social base that I suspect, I don't know who you are, maybe you have a bigger social, doesn't matter, but what I'm trying to say is, on beneficial ownership, Matthew, my own view is most of what you're saying is correct. We had to deal with this, Dikeledi will tell you, when we dealt with the financial sector bill, regulatory bill, right? The first Twin Peaks bill. And some of us were not happy with how far we wanted to go more. So you're picking up, Matthew, on all the issues that some of us who were there in the last term on the NA side, you resonate with. So I think that's what you said is very good. I'm very keen to hear what Treasury has to say about not being more open about it. What's the problem with beneficial ownership, Treasury, being exposed publicly? Why can't the public know it? So also, talking about relationships, you seem all to know each other. So you seem to bounce off each other. It's fine. Are you part of some federation of NGOs? Then can you show us what Treasury is doing here is over and above what, well, I've raised that FATF, but more importantly, have you done some comparisons with how NPOs have been treated in other societies, especially developing societies, but also in the developed world? And in what sense is this different from that? Because I can't have one set of rules, FATF for the developed countries and another for developing societies. So presumably, their regulations or requirements apply to all of us, all countries. And then the question is, what is it that they're doing that's really not? I see somebody's. I can't do this, but somebody's engaged in a chat group with 245 organizations you represent. well, it'll be interesting. Can you send us the list if that's what you said? But you'll have a chance to reply and go on record. I don't think the public can see the exchanges in the chat group unless they link to Zoom. So you must reply. And if you are representing 245, shouldn't your delegation be more representative of the country's demographics? Have you gone to DST and made your points? In other words, we need some guidance from Frank on this and the legal services unit. We will send the documents to them in Koleko. I think they've got it, but you have to send them the YouTube link so they can see what happened here, because the minutes alone won't convey it. So I'm not sure, colleagues, and we need some guidance, how much of what is being submitted here falls within our purview and how much within the Department of Social Development. And the question to the NGOs, have you engaged with the other bill? Have you raised all these issues with DSD and the portfolio and select committees which oversee it? Perhaps you can let us know about that. Now, insofar as the contradiction, National Treasury, between this bill and that bill, you've got to sort it out at the level of the executive, otherwise you're going to hold us up, okay? Now, that's not our issue, really. Parliament, I mean, we will have to go to that development, social development department committee here and select and engage with them if need be, but really it's a matter you should. So then you must tell us, Tracy, how much have you engaged with that department? And how is it possible that Cabinet can introduce two bills more or less simultaneously, or I don't know, but they concurrently being processed through Parliament is what I gather, and there's contradictions between them. So can you respond to that, Treasury? Now, you see, there's this issue about, well, the DSD's not got the capacity to register NGOs, and there's a 10,000 backlog or something. I don't know whether that's an accurate figure or not and exactly what that means, but, and I don't think anyone in this committee knows, but Treasury, can you answer that? And if need be, bring a representative of the DSD to the next committee meeting. Now, I'm not so sure whether FICA, I mean, FIC has the capacity. The state generally is not strong. And I don't know whether FIC has the capacity. Then can National Treasury reply, or the NGOs if they want? When this issue was raised on the NA side, what did the NA committee say in respect of this proposal that, you know, that it's the FIC that takes responsibility for the registration in terms of this bill of NPOs? Now, on the matter of the hearings, look, my own take on it is the following. This bill has been in the public domain since it was first introduced. NGOs also have to show a measure of activism, because that's what you are. So presumably, since you feel so strongly about this bill, you have been engaging with it even from the moment it was gazetted for public comment. I don't know the extent of National Treasury's consultation with you. Maybe you want to reflect on that. So you were there in the NA process. From what I know, it was delayed for 3 weeks. The public hearings were pushed back on your request. There's been lots of media publicity around it. And we, as National Council of Provinces, we couldn't do much until we got the bill. Then there were internal practical problems with the printing of it, as some of you know, I gathered from the secretary. But you're familiar with the issues, right? Now, we are where we are. The country, as Matthew has pointed out from COSATU and many other people, is in a very perilous situation. Now, while it's true that even we pass this bill before we rise, and it's promulgated by the president before the February mandate, not mandate, meeting of FATF, it's not as if the FATF is going to stop the grey listing, because they require the institutions of the state that deal with money laundering and terrorism financing and the like to be operative, to be effective. And they've not been as effective as they should be, though they're beginning to be effective. But, you know, it's a test of how many people you take through the court process. More importantly, how many of them are prosecuted and how expeditiously. So we can pass this bill. That's not the sole criteria. But what is important about passing this bill is it shows intent to act from the parliament side, but it must be complemented by effective oversight over these institutions by the respective parliamentary committees in both houses and in the provinces where there are provincial roles for those legislature committees. Now, yes, it's true, you got the version on Friday afternoon and you're appearing here today, but you're appearing here if you want to on Friday. You'll appear here next week when we process the bill. In our committee, we allow you to make submissions till the very day we vote on the bill. So if you're talking about public participation, we have said it's not ideal. I myself have been saying it as the chair of this committee, and we've put many of the statements I made into the report. Dennis has also been raising it. So we're acutely, excruciatingly aware of the constraints. But we haven't had this sort of situation for many, many years, and I've been around for a long time. Never before, well, not for a very long time. I think the last experience I've had of this sort of pressure was on the NA side when we were reaching the December 2000 local government elections. I think, Dennis, you were in your nappies then. We were processing the amendments, and if we didn't get them done on both sides, both houses, we wouldn't have had the elections on December. What was it, Dennis? 1st, December 2005. Was it the 1st or the 5th? I've forgotten. And we had to rush. And we worked then 24 hours a day. We used to sit from morning till night. We exempted from the House. And if we have to do that for this bill, we will. We will seek exemptions. I've already alerted the NCOP powers that be last week when we were out there in KZN. That this day said, no, we'll give you the full exemptions. But you see, I think given the circumstances, we agree it's not desirable. I don't think it's the end of the world, colleagues from civil society. You've been with this bill from the first time the NA committee actually, you know, brought it to the NA public hearings. And then you've been engaging with them, and you're engaging with us now, and presumably you're monitoring the changes they were making. So what has come to you on Friday afternoon, late Friday afternoon, it's not like a shock. So you will have to balance out whether you're going to go to court, which is your right, and say, well, it was squeezed through the process and you're unhappy and all that. That's your right. But my own experience has been half the time that's a legitimate thing that civil society does. Half the time, it's because they're unhappy about one or other provision of the bill. So then they go to the court. And what usually happens, like in most parliaments in the world, in a similar situation, the court says you have to redo the bill. Much of what was done in the first instance is repeated. Maybe an odd thing will change here and there. Then people can go back to the court and say, well, they just went through it nominally. That's your right too. Now, you say, extend the, well, first let me ask you, do you think the quality of your inputs would be substantially different? And the point you make substantially different if you were given another month. My own feeling is that probably not. The main points you've covered, you've done, as Dennis said, a very good input overall. Whether one agrees or disagrees, the quality of what you've said, you're obviously very adroit and very professional. So, you know, I can't see how substantially different or much improved your bill would have been. I mean, your submission would have been, even if we had the time, but that's not, you can still go to court. On the matter of keeping the door open, the door is open. People can come to us anytime. We don't just have, people want to make representation, they can do so. You can do further representations. But I don't think, frankly, that many more people are going to come. On the NCOP side, it's very unusual. We get very few except on 76 bills, very few public submissions, regrettably. And yesterday was very interesting, 13 submissions. But that's unusual. Normally it's a few. Now we've got 4 other submissions, which are brief. And some of it overlaps with what you're saying, but the members will have to look at that. But you do agree that there's been improvements in the bill. It shows the public hearings out, because when you people went to the NAU or others who are from civil society, they did take you seriously. The chairperson, I know, is very harsh on the National Treasury, as we've been. And in fact, there have been improvements, right? And I've been following some of what we've been on the media and other ways. On the matter that I want to raise about the relationship between what is constitutional and what is policy, I have addressed it partly, but, you know, I don't believe that you can present, it's very easy. Sometimes it's possible, but most times when people present what they say are constitutional problems with a bill, it's not like an abstract scientific sort of argument, okay, that everybody can agree with. There's normally an ideological underpinning of it. And to some extent, it's possible, I don't know, that the stream of thinking you have follows from a particular relationship between the individual and the state, the Bill of Rights for individuals and the state. And you have a right to that. I mean, Colin Eglin, one of those brilliant politicians I've come across, who expresses that. Or your Rene Talliard from your Helen Suzman Foundation, Dean Smuts, people like that. And it's very compelling. I may agree or disagree with it, but there is an ideological underpinning usually. Maybe it doesn't apply here. I find that hard to believe, just like my comments here on the constitutional issues and the relation to that and policy are not outside of an embedded ideological disposition. So, you know, the thing that strikes me, maybe you want to answer this, how is it that the National Treasury's lawyers who are here, they must answer for themselves, the state law advisor, Parliament's Legal Services Unit have all said okay to this bill. They can't, remember, bring a bill to Parliament unless it's constitutionally sound. But they are not the arbiters. Ultimately, it's a constitutional court. Why do you think you are absolutely right and they're all absolutely wrong? Ultimately, it's for the courts to decide, the highest court in the land. Then on the issue of, finally, a public hearing, as it is imperative for us to look for compromises, so it is on you, civil society, to say, look, whatever our differences, there are times we come together. We are one country, one people ultimately. Never mind that on the ground, most of us don't see it that way. But that is what our constitution enjoins us, whatever our differences. We are in a unique situation. Treasury must be held to account for. And Simon Moletsani has raised it yet again, but remember, Simon, my brother, we've raised it about 4 or 5 times, but let them say it again in this forum, because this is a public hearing. And let civil society tackle them on that. But what I'm saying is, where are the compromises you're offering? I don't see it. And Treasury, can you also wake up and offer some compromises, right? We want to hear from you, Treasury, a less dogmatic, more conciliatory view. And then if you're talking about public participation, as we've done before, you know what? You will have to work over the weekend and sort things out. If by Friday, 5 o'clock, we're still as far apart as we are now, then you will have to work over the weekend and sort this matter out. I remain unconvinced that this bill will need to be rushed, but on the other hand, we don't have enough time. What is the harm in Parliament sitting the whole of Saturday, although I've got other commitments like many of you have, the whole of Sunday? What's the problem? What is the problem with civil society coming here for the whole of Saturday and the whole of Sunday? So let's not make public participation the big issue. I'm not convinced it is. It's irritated us and it's impacted on us negatively, but we can rescue the time. So if you look at a bill, let's say if we had an extra month, we might have spent 40 hours on the bill. Well, I'll tell you what, if need be, we'll spend 60 hours on this bill in the next 10 days. So I don't think that should be made an issue. So what I'm saying to you is, We can carp about the public participation. But you know what? We are where we are. I'm saying to you, we will meet with you. We will get them to meet with you and settle issues first, if it's possible. And then you come back to us on Sunday. Or I will consult with the members. Monday is a bad day, colleagues, because we're all flying to Cape Town because we're having hybrid sittings next week, right? So Monday we can't meet because we all fly at different times, because Tuesday we have to be in the house. So Sunday, please keep it available if need be. And we give them Saturday to negotiate. But let's see where we get there. If you can negotiate with them tomorrow on the issues, Treasury, and at the same time deliver a formal, because your discussions are informal. You're going to come to us. We make the final decisions. So the options are there. So when you're talking about public participation, this is the offer I give you. Members can dismiss it if they want, but nothing stops me as a committee chair from meeting with both sides, and those who are free to come informally. We've done that too before. The DA can go and check the rules. Frank can tell them we've done it many times in the local government arena when we met with people. And Dennis, that property rates bill, I think I wrote about it. I'll send it to you. We spent 40 hours, myself alone, meeting with stakeholders and reporting back to the committee repeatedly, apart from the over 100 hours I think we spent on that bill. So please, let's look for compromises and let's find out why some of the things. Can you also tell us from your point of view rather than Treasury alone? Your point of view, civil society, when you made these presentations to them, or similar ones, well, earlier versions of what you said, they turned down some of your proposals. Why did they turn your proposals down? What did they say in response to what you said? Okay, so there's a lot there. You're not required to answer all of them. You'll be engaging with us on Friday. I don't normally talk so much, especially when other members haven't spoken. Dennis might disagree, but this is too important a bill to make public participation something abstract. We can do it concretely. We can spend 60 hours on this bill. It's not a problem. We can find the time. Plus, we can seek exemptions from the House. The difficulty there is colleagues from civil society. I have to negotiate with something like Fani, who's one person, is a small party. And then there's Moletsane from EFF. He's also a small party, though he doesn't accept that. But and Dennis can swap with Willie Alcamp and all. He's got more latitude. We can meet while the House is sitting and then stop if the members have to go and take part in some debate and come back. Okay, over then to members. Do you want to say anything? Nicole, you can come in when you come in the way the system operates here. Who from the committee wants to say anything as far as the process goes, so that I've proposed? Or you want to come back at the end? Maybe you come back at the end. Let's see where things go. And then on Friday, you can give me your responses about meeting on Sunday. Okay, so then we go on to who's here?
Hello,
no hands up. Yeah, yes, please, Njadu. Go ahead, my friend.
Hello, Chair.
Yeah, do please speak.
Yes, Chairperson. I think I only want to make a comment on the, because you have raised a mouthful in terms of how to look at these bills. So and I want to emphasize also on the issue of the public participation and fully support in terms of the number of points that you have made. So, Chairperson, I think in terms of going forward, I am covered. Thank you.
As I understand it, you are prepared to work outside the normal parliamentary hours, and we can seek exemption once after we've consulted the minority parties. So about time, the NGOs will make themselves available. Okay, we will meet whenever. We'll do the same number of hours as if the bill was tabled last year, if they want. But let's not make that an issue. Okay, now people have put comments in the chat group. I can go through them, but why don't you speak to it? There's plenty of time. We've got what, at least another hour and 15 minutes. So please, whatever you're saying in the chat group, am I right, in Nkululeko? The public can't see it, right? Unless they link via Zoom. Is that right?
That's correct, Chairperson. Only
Fine.
people
So
who
can
are
you
in
say
this
what you
platform
said? Okay, now I'll give each of you, let's see what's the time now. I can give each of you another 10 minutes, which is very long. Let me just spoken for at least 25 minutes for those of you who chose the full time, and some of you even more, but others less. So here it is. If I gave all of you, that's 40 minutes. Yeah, you're gonna have 10 minutes. Cool. Okay, as my secretary loves saying. Oh, our secretary, cool. Everything's cool for him. Okay, and it's cool for me right now. Go ahead, starting from the first one. NPO working group.
Thank you, Chair. Loads, I've been battling to get everything down in terms of answering things, but I think I do have some answers. I think the first thing we want to say from the NPO working group is we don't want to stop the bill. We understand that this thing needs to go through. So the presentations that we're making are on some details of amendments that we think can be made now, and then the bigger question of the location of the registration is something which we think is part of a bigger process. We appear to have undercut ourselves in terms of your argument by doing a decent job of our presentations. But in terms of the complaint on public participation and that being raised, I just want to say from my perspective, certainly, it's prior to the bill emerging that there wasn't enough broad consultation with the sector, that when it first emerged, it was a surprise item to many. And so that's why it's been such a rush to wrangle with it and deal with it, because it did have such large implications, and that process from then on has been very short. To give Treasury credit, there is in existence, I don't know if you've seen, a legal opinion which was gained in answer to our last submissions on constitutionality. I'm giving credit to Treasury that they heard the voices of the nonprofits in the room and in fact compromised despite some of the parts of that opinion that was given. So Treasury certainly has heard us and has made some major amendments. It's adjusted from saying blanket every knitting club, to coin the phrase, in the country had to register, to defining a specified class of organizations that it only now requires to register. Then just on the position of, I echo your sentiment on the lack of a league of NGOs. It's regrettable. And my hope is that this process of engagement may in fact lead to such a thing. My colleague Anne has posted, in terms of the NPO working group, that there are about 10,000 large and small nonprofit community organizations that are within the reach of the nonprofits who have worked together here. And also just to get to the crucial question in terms of ideology, I think you're right. The exposure of beneficial owners against the right to privacy is the crux of the ideological argument. And because nonprofits are so broad, as you say, there are some in the room who would say, absolutely, let's know the names of everybody at the bottom of everything, show all of their dirty underwear and let it be known. And then there are organizations who run homes for people with disabilities and whose beneficiaries may be from groups which are marginalized and which want to make sure that their beneficiaries are protected and that there isn't an exposure necessarily of even of people who are on their boards who may represent those persecuted or marginalized groups. So there is, and that's one of the reasons I think that there's such a disparate. So in the previous presentations that were made, there were certainly people who had a view that this was a draconian opportunity being taken. Some colleagues, especially those who remember the Fundraising Act and how that was used by the apartheid regime to control NGOs, do fear this. And there are international instances, I don't know, Anne, if you can correct me, was it Pakistan where this was used, and a whole lot of nonprofits were deregistered, and that on ideological grounds. Certainly, there have been many who've made presentations in the previous context who have referred to international studies, and that, in particular for me coming out of that, or for our group coming out of that, is that where there is a compulsory registration of nonprofits, it's generally with a body which has an independent credibility and is not reporting inside of a government department, which is our main contention here. I don't know if I've answered all of the things that I've put on my list, but that's what I have to offer. Thanks.
Helen Suzman Foundation.
Thank you, Chair. I'll be very brief, and you raised a number of issues which we could talk about at great length. But I think what is important for today's discussion, I just want to mention 2 points, and I won't put them in legalese. I'll try to be as clear as I can. The first point is, against the background of potential grey listing, we understand the need for this legislation. We're not against the legislation in principle. We do not necessarily see it as some draconian measure to achieve all kinds of other things. That's the first point. And secondly, which is just as important, is we want to underline the importance of finding a mechanism that actually achieves what it is supposed to, without getting involved in areas which are not relevant for the current purposes. And I think it is absolutely essential that an efficient mechanism is put in place. And that is why Nicole from NGA put forward the FICA proposal, which we have supported. I think it's a logical way of dealing with this without having to get involved in all kinds of other areas. And the existing FICA legislation provides the background and the structure for what government needs to do in this area. So I would just like to limit my comments to those 2 areas, and I hope that would have clarified a number of your concerns. I don't want to go down the route of discuss public participation further. I think it's a very short time frame, and we need to do what we can within the short time frame. Thank you.
Okay, next, you know the order in which you spoke.
Thank you, Chair. Yes, I'd like to start by saying that we think the objectives of the bill are laudable objectives, and it's important and it's necessary. And obviously we agree that we want to avoid grey listing, and we don't want money laundering and terrorism financing through our MPO sector at all. Our approach is to look at ways that when legislation is passed, that it meets laudable objectives, that it passes constitutional muster, because nobody wants their work, the hard work that's being done in this department and hard work being done in parliamentary committees and by stakeholders to be in vain. And with that effect to maximize fundamental rights and freedoms, because that's the objective of the Constitution as we see it. We don't necessarily see it as, we don't think Treasury is trying to undermine or curtail MPOs. I think there's a situation that with the grey listing is looming, and people are trying to find ways to avoid it. What we're just saying is make sure that what is proposed will actually achieve that, because that is a laudable objective. But let's put together a piece of legislation that achieves us. We all want that. And we are very grateful that Treasury has listened to stakeholders. There have been tremendous improvements to the bill. Definitely. There are just a few little things that can be tweaked. Why are we suggesting it? Not because we want the bill to go away. No, we want the bill actually to be effective. So that's why we say make sure that those MPOs that are affected, that's not open to constitutional challenge, and that whoever oversees this oversight role, they can actually do their job, and it will be effective at preventing money laundering. And what is the MPO? Then that's why we say the FATF, they don't require that all organizations, all MPOs be registered. And there are certain things that we noted, for example, MPOs that are already registered for tax exemptions and things like that, they can be excluded from at risk. So MPOs that are registered with SARS as PBOs, those that foreign companies registered with CIPC, NGO laws also made very good proposals. That's a way to limit the subset of MPOs that need to register. It just makes the legislation more constitutionally sound. And the moment that's in, those little, very few little tweaks is needed, we would say the legislation is good to go. And then we have a good piece of legislation that can achieve its objectives, but we also maximize the freedoms of the MPO sector. Because it's also definitely not to the benefit of the MPO sector that MPOs are misused for money laundering and financing of terrorism. So that is our submissions in a nutshell. Thank you, Chair.
Right, Kosatu.
Yeah, no, thanks, Chair. Look, I think just a few things, because most of the question wasn't really aimed at us or more to the NGO colleagues. But I think to Honourable Ryder's questions around the issue of the MPO backlog, I think really the solution there is about capacitating the Department of Social Development. We shouldn't be seeking shortcuts and laws because departments are not bothered with capacitating themselves. They have to do some real work. But we do want to appreciate the kind of efforts by Treasury to resolve some of the concerns in the National Assembly. And I think obviously, Chair, our kind of foundation as COSATU is that we have to comply with the timeframes and requirements. We have to avoid the grey listing. And the consequences if we fail to do so are really quite dire. And I think we did appreciate this, that SCOF did give us some additional space for public participation, albeit not ideal. And I think, Chair, to be fair to Parliament, this is a problem across many departments that we see time and again take 2 years, 3 years, even 5, 6 years on bills. Then they finally wake up and they bring it to Parliament. Not just Treasury, but we've seen this almost every single department. It really does have a negative impact upon progressive laws which should benefit the society. It has a huge impact upon Parliament and public participation. But it's not just Treasury alone, it's almost every single department. To Honourable Molasani, Chair, we ourselves ask why do departments delay in submitting these bills time and again? And I just simply think it's because, well, they don't feel a sense of urgency many times. And relief does put us in a crisis. For example, as we approach elections in 18 months, it means we have to get all our bills to Parliament by February, March next year. Otherwise, there'll be another 2 or 3 years delay if we don't get them sorted out. So it is really generally across the department's problems. I think, Chair, just to the Honourable Chairperson's questions, I think we're quite pleased that the Chairperson has remembered our comrades in Mongolia. It's been quite a while since he mentioned the peasants in Outer Mongolia.
Out of order.
As they're a historical ally of the revolution. But Chair, look, even in Mongolia, you will see the consequence with a huge amount of mining investments in that country. If you don't have a capacity state to deal with corruption, to deal with huge capital who can buy the way through rules, there is a real possibility of corruption. I think, Chair, we've seen in South Africa in the last decade alone, the issue of the decapacitation of the state, a real pandemic of corruption. There's real victims to it, be it a municipal worker who doesn't get paid, be it a nurse who must cover for 2 or 3 vacancies, be it schools who have got declining infrastructure, be it police stations with a declining headcount. We've seen real impact upon our members, and there's a real consequence to it. So I think for us, what's critical, Chair, is about rebuilding the state capacity. There must be checks and balances, and I think there are those in the bill. Chair, and look, we appreciate NGOs may not be keen for many of these issues, and I think it'd be good if they can find some middle compromise with the Department of Treasury and DSD. But I must also say, Chair, as a trade union, we also have to comply with the Department of Labour in terms of our own registration requirements. It is a nuisance at times, but I think it is for a better good, because if we didn't have that compliance as trade unions, we can be sure that some of our comrades would misbehave, and there'll be consequences in terms of decapacitation of the trade unions as well. So the laws are there not because we enjoy them, but at times make sure we abide by the spirit and the objectives, etc. I think, Chair, just lastly on the issue of the beneficial ownership, I mean, we would have loved to see more clauses in the bill giving more granular detail. But I think, Chair, we want to hope Treasury will provide that space in the regulations. They will come to us when the President signs the bill towards the end of the year. Let's get something done by the first quarter, first half of next year. But I think the point is, Chair, there needs to be full transparency. There needs to be live access to beneficial ownership to who owns the company, not just for the issue of terrorism, but also the issue of corruption, etc. And we've seen, Chair, at times that, Parliament will pass very progressive laws, and then afterwards departments ignore them. So the SCOF committee, Chair, you would know from the previous Parliament, spent a lot of time on the PIC Amendment Act to say there must be full disclosure of all PIC investments to the public, to Parliament, etc. And that bill was signed into law a year and a half ago, and it still hasn't been effected. The PIC is still declining to disclose those investments to the public. So there's a real challenge that we pass progressive laws, we then have to make sure and chase departments and entities to make sure they implement them. So I think that's it from my side, Chair. And yeah, just to thank members for giving us space. Thanks, Chair.
Okay, Treasury, do you want to reply, please? Your initial replies. Now, civil society just understand that they would have read your submissions yesterday, if they got around to it, and listened to you today. And they obviously need some time to put it together and consult with their seniors. So there's not like a final reply for you. What we have here is an initial response to some of the issues. So over to the Treasury team.
Thank you, Chair, and thank you to the members and the stakeholders who provided some useful and thoughtful submissions today. Chair, there's obviously a huge range of issues that have been dealt with in the submissions themselves and the follow-up questions and discussions. I'm going to sort of start off by dealing with some broad issues that were raised. The first one, Chair, is something that you had in part already addressed, but I thought it may be worth just underlining again, and that is just, maybe communicating, and perhaps we haven't done a great job at this, but communicating to the NGO sector a little bit about why we're doing this and why it's critical. I mean, I think a lot of the focus has been perhaps on the medicine, and perhaps not enough on just having a quick discussion on the nature of the disease. So the purpose of the bill, to assure the stakeholders and the submitters, is really to narrowly meet the identified deficiencies that FATF identified in the mutual evaluation to avoid a grey listing. Certainly, Chair, we don't have any broader ambitions to affect how the NGO sector operates beyond this very narrow objective. And we believe that the design and the subsequent amendments that we've made to the clauses really reflect this very narrow purpose that we have. It may be useful just to underscore that grey listing will disproportionately affect NPOs and remittance services providers. This is not just our view, it is the empirical evidence of other countries that have been grey listed. This is because the most affected people and sectors from a grey listing are those that traditionally have difficulties in providing stringent customer due diligence or proof of identity for receiving and sending money. So what we've seen in the region, in sub-Saharan Africa, as well as Oceania, which has been massively affected by grey listing and the effects of de-risking that are a consequence of grey listing, is that the people that are most affected will be those that do not have the ability to formally identify themselves for the receiving and sending of funds and money. And so we just really want to underscore, Chair, that we're all really pulling or trying to row in the same direction here. We, like you, absolutely acknowledge the critical and the central importance of the NGO sector, and for them to continue this really important and central work, a credible financial system that would allow them to receive and send funds required for their operation is really important. And that's the objective. Chair, sort of narrowing down on some of the specific comments and submissions that we received. Several of the submissions that have been provided for have been previously submitted to the Standing Committee on Finance, and we had responded to those formally then. But Chair, as you indicated, we will give these additional resources, these additional submissions, the detailed responses that they deserve by Friday. We do note that in relation to the NGO Act amendments, the provisions are currently contained in the B bill, which were amended in the National Assembly, broadly did take into account the submissions that were made in the Standing Committee on Finance. And Chair, I think that has been reflected in some of the engagements and the submissions made by the NGO sector today. And that reflects the extensive consideration and engagements that we undertook, both within the committee, but also bilaterally with affected stakeholders, and certainly those that had made submissions in the standing committee. Chair, we aim to achieve an appropriate balance in addressing these concerns. But like I say, Chair, we are also seeking to make sure that we address the FATF identified deficiencies. Honourable Ryder, I think, made a very important point, which is that there's no use in simply passing a bill that is not going to be implemented. And Chair, this is something that I think that you also touched upon. The only way we are going to successfully avoid a grey listing is in part getting the laws, which is what the bill in front of this committee really seeks to do, but also ensuring that the laws that have been passed are effective in addressing the objectives. So this, Honourable Ryder and Chair, is simply half of the exam that we need to pass. The other half of the exam is to demonstrate effectiveness, and we are mindful of that, and we are not simply we would not simply be satisfied by nominally passing the law that we think had no reasonable prospect of being implemented effectively, because that would run counter to our principal objective, which is avoiding the grey list, Chair. Chair, like I mentioned, we are going to deal with the comments in a more substantive way, but maybe just to very briefly touch on the comments that were made by the Helen Suzman Foundation in particular, Chair, who alluded to a misalignment between the law, the General Laws Amendment Bill in front of the committee today and the NPO Amendment Bill. What is important to remember, Chair, for yourselves and I guess for the Helen Suzman Foundation, is that we've been working very closely with the Department of Social Development throughout the entire process. Chair, the NPO Amendment Bill is not currently before Parliament. This bill is, and having passed the National Assembly and now being in front of the National Council of Provinces, Chair, will mean that the subsequent bill that will be the NPO Amendment Bill will need to align to this law. So we just wanted to reassure the Helen Suzman Foundation that we've been working very, very closely with them. That bill is not currently tabled in Parliament, but when it does, through the engagements that we've had with those colleagues and the fact that this bill would have been passed, hopefully, will require that those amendments are aligned to what we are doing right now. Chair, the comments by the law firm Weber Wenzels, which were extensive, Chair, will be very carefully considered and presented to you on Friday. But before just wrapping up and handing over to Janine, who's going to deal with some more of the details, Chair, maybe just to underline one final, I think, important point, which was mentioned by one of the submitters today, and that is that we had obtained a legal opinion on the constitutionality of the NPO amendments that we're proposing in the bill. Chair, that has been it was submitted when we wrote to the chair of the SCOF, and we provided a copy of that to your committee, Chair, as well. And we would be happy to resubmit that to address any lingering concerns of the constitutional nature that were dealt with in that opinion. Chair, let me pause there and hand over to Janine to deal with any other issues that I may have forgotten. But before I do, one final one, and this is I'm very happy to have a opportunity to deal with this because I have seen this quoted not only in this committee but also in the media. But I wish to categorically and very clearly state that the bill was not given or developed by National Treasury in 2017, as stated in some areas. Chair, the report that was submitted by FATF, which represents the basis of the bill that is in front of the committee today, was published in October 2021. From that period, we've been very closely engaging with departments. Because of the nature of the bill being an omnibus bill, a lot of the aspects not falling within the area of competence of the Ministry of Finance. From October 2021, where we received the mutual evaluation report and then developed the bill and engaged with the government departments, as well as gone through the cabinet process, the bill ultimately being tabled in Parliament in August of 2022. Chair, I think that I think it may be just important for us just to broadly recognize that there has been significant complexity in drafting the bill because of the reason that I've just outlined. But really, Chair, we don't see this as a massively excessive or certainly not anywhere near the sort of timelines of 2017 that we have noted have been quoted around. That is nowhere near the timelines that we have had. Let me stop there, pause there, Chair, and pass over to Ginny. Ginny?
Thank you very much, Honorable Chair and Vukile and honorable members and stakeholders. I think I'll primarily try to briefly summarize the amendments that were made to the bill in the Standing Committee on Finance. Honorable Ryder had mentioned that it would be helpful just to get a brief sense of the nature of the amendments. So I will just put up a couple of slides just to show briefly the specific provisions that were amended and the nature of the amendments that were made in light of the public comments that were received from the stakeholders in the Standing Committee on Finance. So I'm just getting to the right slide here. Okay. So in the light of all of the substantial comments that were received regarding the proposed blanket mandatory registration of all NPOs under the NPO Act, and after further careful consideration, significant drafting refinements were proposed to the Standing Committee on Finance and which were ultimately adopted by the National Assembly. And so at this stage, the bill as it currently provides would require only a subcategory of NPOs that would be required to be registered. And these would be NPOs that make donations to individuals or organizations outside of the Republic, or NPOs that provide humanitarian, charitable, religious, educational, or cultural services outside of South Africa's borders. So the provisions have been amended so as to specifically narrow the category of NPOs who would be required to be registered. And in light of the specific concerns that were raised regarding constitutionality, especially impacts on the rights of the freedom of association, freedom of religion, conscience and religion, and the rights of cultural and religious organizations, we really took those comments seriously, and we did request a legal opinion, particularly from senior counsel, particularly to look at the required licensing provisions in the bill. And so ultimately the final provisions that are included in the B bill took into account a couple of recommendations that were made by the senior counsel opinion. And I'll touch on those briefly in a minute. So we also proposed, and it was adopted, that wording be included to explicitly make it clear that the Directorate of Nonprofit Organizations does not have the discretion to refuse registration if the requirements of the Act are complied with. This already is the case in Section 13, subsection 2, but in order to ensure that there's absolutely no doubt about the scope of the powers of the Directorate relating to registration, we proposed explicit wording. And similarly, also wording is included to clarify that the grounds on which a nonprofit organization could be deregistered could only be exercised in respect of non-compliance with requirements in the Act or with its constitution. And so this, again, that's effectively what currently is provided in the Act, but now the bill would make that scope of powers even more explicit. And also, concern had been expressed about the potential power of the Directorate to require NPOs to make changes to their constitution, and wording is now included to make it explicit that the Directorate cannot require an NPO to change its constitution, but only may refuse registration if the constitution does not, in fact, cover the matters required in terms of Section 12, subsection 2. And those are objective categories of matters that must be provided for. It doesn't say how they must provide for them or other aspects about the activities of the nonprofit organization. So the scope of the powers relating to amendments to the Constitution are similarly clearly delineated. And we also highlighted in the Standing Committee on Finance that all of the public powers that the Directorate has in terms of the legislation must be exercised in accordance with the Constitution and in compliance with the Bill of Rights and the Promotion of Administrative Justice Act. And so we had considered perhaps providing for that explicitly, but advice was received from the state law advisors that, generally that is not a necessary and a required drafting practice because that does necessarily apply. And so it is submitted that as the powers of the Directorate have in relation to registration, deregistration, and the ability to require amendments to the Constitution of NPOs has been very clearly delineated through the addition of explicit wording, and also in light of the application of the Constitution and the PAJA, the powers of the Directorate may not be exercised in a manner that potentially may infringe on the rights to freedom of association, freedom of religion, freedom of cultural and religious groups, and all of the other rights in the Bill of Rights. And the Senior Counsel opinion particularly analyzed the licensing provisions and in the bill and concluded, based on an assessment of the constitutional jurisprudence and the application of the Section 36 of the Constitution, that the provisions generally were constitutionally sound, with the exception of a reference that had been included in the tabled version of the bill that amendments or that licensing in terms of Section 12 of the NPO Act would be subject potentially to additional prescribed licensing requirements and transitional arrangements that might be included in regulations that would be subsequently prescribed. And Council recommended that those references be removed from the bill and that licensing of NPOs who would be required to be subject to registration would only be subject to the very objective requirements and processes that are currently contained in sections 12 to 14 of the NPO Act. The only additional relevant aspect would be the timeframes within which they must register, which would be specified in a notice that would be published in the Gazette. And so these proposals were proposed and they were adopted in the Standing Committee on Finance. And so the current provisions in the bill as they provide, so in section 12, this is where many of the amendments were made. So what now is subsection 1B clearly defines the limited scope of the NPOs who must be registered. And also in paragraph C, references to transitional arrangements or subsequent regulations and licensing requirements have been removed. And also, it also is now provided that a registered nonprofit organization, whether it is in fact registered in terms of the Act or not, must comply with the requirements of this Act. So this then just applies to those NPOs who would be required to register. And then the addition of subsection 4 provides the explicit wording that the amendments may only be required to make an alteration to the Constitution if it addresses matters, to ensure that it addresses the required matters specified in subsection 2. And then in section 13, the subsections 7 and 8 are now added to section 13. And so this clarifies, subsection 7 clarifies the powers of the director to refuse to register. And that may only happen if there's been non-compliance with the requirements for registration, or has failed to address non-compliance that it has been notified of as referred to currently in the Act. There's already a process and sort of in terms of which, if there's non-compliance with licensing requirements at the time of application, how that would be addressed. And it's also now provided that a nonprofit organization that has submitted an application for registration is deemed to be registered unless the director has given notice of that it is proposing to refuse to register the NPO, and the processes that must be followed in that case have been completed. So these provisions clearly delineate the powers of the director in relation to registration. And then there's also the addition of a requirement that the information that must be submitted relating to office bearers of nonprofit organizations must be kept up to date. And this was in response to submissions that were provided to the committee. And then in section 21, a new amendment provision would be included to explicitly state that the director may only cancel the registration of a nonprofit organization as contemplated in section 20 and this section. So that again clearly limits the scope of the powers. And then in response to comments that were received previously in the tabled version of the bill, certain contraventions of the Act were designated as being offenses. And so then they would potentially be subject to fines or even potentially a period of imprisonment, in accordance with the criminal procedure. But now in response to recommendations, these contraventions would be designated as contraventions of the Act and would not be offenses. And then they would be subject to an administrative sanction. So those are the amendments that we did take into account and provide for in the Nonprofit Organization Act amendments in the bill in response to the submissions. So then just briefly to touch on the comments of Kasatu and Saktu, the concerns about public access to information that will be gathered in terms of the legislation relating to beneficial ownership is certainly noted. And the access to the information will be provided for in accordance with regulations that will be subsequently promulgated, and they will be developed by the relevant ministers in consultation with the Minister of Finance. And those regulations would also be published for consultation prior to promulgation. So it will be endeavored to appropriately, take into consideration the importance of access to information in the development and promulgation of those regulations. And in response to the Helen Suzman Foundation submission, we would just reiterate that we will certainly engage with colleagues in the Department of Social Development, who we've already been working on with this bill in relation to supporting them with the further processing of their legislation, also taking into account, the important submissions that have been made in this process. So I think that completes our responses for now on the submissions today. We will certainly provide a great deal more detailed responses on Friday, particularly regarding the submissions relating to the directorate and the capacity and situation of the directorate in terms of legislation and the ability to effectively perform the functions. Thank you very much, Honorable Chair and Honorable Members.
Thank you. Right. Do members want to come back now? I don't see any hands up. In the meanwhile, there's some comments in the chat group. I'll just go there. Excuse me. Yeah, Dennis raised the ability to implement. You've answered that. Then William Bird, this might be William Bird from the Media Monitoring Association. I'm not sure, but whoever it is, he says, I think the NGOs who have participated have understood the key issues. Our concern was the responses were not proportionate and appropriate to addressing the challenges identified by Treasury. Yeah, that we understand, that's been covered. We are well acquainted, says Nicole, with each other because we have been in so many meetings together over the past weeks, right? The simple reality, says William, is that the initial draft and the proposal on the table from DST was patently unconstitutional. Well, of course, that belongs to that area, and only insofar as it conflicts with our bill, do we have to deal with that issue. That should be taken to, as it seems to have been, to DST, the Portfolio Committee. But there's no bill even before the committee, as I understand Vakil is saying. So it's draft bills at this stage. Each submission, says Jenny Wright, made by the NPO working group have been updated based on the latest documents provided. That is, the submission was updated based on what was the B version of the bill. Just start fine. That's obvious. Well, that has to be done anyway. But DST has asked, said William, for public comment on the draft bill, where they had failed to make the changes we note. But that's a matter which must be dealt with by the relevant Portfolio Committee and Select Committee and Department. There's no guarantee if you make submissions. I'm sure William knows this, that the executive and parliament particularly are obliged to accept them. Please, can we have a copy of the opinion? Yes. William, can you give us your email? If Nkululeko doesn't have it, we'll send it to you. I think that the opinion, I know the opinion reached me, from what I can tell, but I haven't looked at it until, because you forget things until the bill is before us. And so it is this morning with the public hearings. But can we send this legal opinion out to everybody in Nkululeko, both members of the committee and others who are here from civil society? Dennis Ryder wants it emailed to him as well. Well, of course, we'll email it to all the committee members. So Vakila, just send it to Nkululeko again, and he will send it out to all of us. All right. Now, do the NGOs want to say anything? No.
I don't see any hand, Chairperson.
Okay. Well, in that case, we're drawing to a close. just to draw attention of members that tomorrow, after the House rises, I think I'm right in Kululeko, I'm sure Tikaledi is here, that we have in Jadu a committee meeting of SECOA. And then on Friday, to remind you, 10 o'clock to 1 o'clock is SECOA, 2 to 5 is this committee. Finally, to repeat, well, look, just some observations. I don't want to go on because I really would like to read this. Now, for example, my friend, you gave such an extensive reply, Janine. You went far beyond what I thought you would, but it's good because it gives the opportunity for civil society stakeholders when they come on Friday to have a better sense of, what was done. So, look, I've got 4 comments here, but I'll leave that for now. I think let me read your submissions. Hopefully we will get it National Treasury by tomorrow evening, right? Because Friday is a very busy day for us. So Vukile, can you deliver? Because you've covered the issues anyway here. So can you deliver it by, let's say, 8 p.m. tomorrow to Nkululeko to send out to committee members, your replies? And the legal opinion, can we have it this afternoon in the next hour or two? Looking at what you've just said to me, both of you from Treasury, your changes have been more substantial than I thought, looking at what the media had to say. But remember, we haven't looked at the bill clause by clause. We got the overview, your briefing. So some of what you said, Janine, is a bit difficult to follow. But of course, we'll get the chance to read it. And that document you just gave us now can also be sent out in Kululeko. If there's nothing else, I would like to thank in particular the civil society stakeholders and Bukile and his team and to the members. So we shall see you tomorrow evening in the one committee and Friday morning and Friday evening. Thank you all. And just a reminder again to the civil society stakeholders, it's at 2 o'clock, virtually, of course. Dennis, together with the, yeah, that's what I just said, Dennis. John, right, who's this now? Oh, I don't know why people are effusive in their thanks. It's their parliament. They, they have the right to come here, but I suppose it's a courtesy, so we appreciate the courtesy. John, what's your Jenny, right, thank you. Look, the other option may be, I'm just thinking before we break up, of course, we have to pass a bill that's constitutionally sound. But once again, we're not lawyers. So, I suppose the person that's most appropriate on your side of civil, so I can't choose for you, is Janine. Frank will have to do some work, so I don't know when we can do it. As far as the constitutional issues are concerned, I don't think COSATU is affected, so the 3 NGOs, lawyers preferably. I think the cause for justice representative looked like she was a lawyer, but I don't know. Well, preferably lawyers, but others can be there from civil society. With the lawyer from Parliament and the lawyer from the Treasury, you can settle those issues in a subcommittee meeting. And then you'll bring to us the outcome of that. That can be done over the weekend. And members, can I discuss you offline? If necessary on Friday, we can maybe have a meeting. I know it might affect churchgoers, so maybe it's 2 to 5 on Sunday. But it clashes with other things in my case. So, but I'll forego the other things that do, or on from 10 to 1, because we can't do Monday. Okay. Well, the other option is, can people reply by WhatsApp to me? You see, the other option is to have a subcommittee if need be, which we've done before. We can have one at least DA, both of them, one EFF, or you can bring somebody else, Simon, probably the chair and the whip from the NCOP side. And because of the situation, maybe it should be Njadu and I. We can meet on Sunday morning if you want to deal with the non-legal issues, the policy issues and what can be done. Okay, right. Having said that, we can confer through WhatsApp. Will members of the committee let me know if they're available on Sunday morning or afternoon, and then let's see tentatively what happens on Friday afternoon and then decide whether we do meet. Thank you all.
Thank you.
Thank you.
Recording stopped.